You need to have a conversation with your clients about how you use AI in your business. But that conversation is the last step in a process, not the first one. Before you say a word to any client, there are two decisions that you need to make for yourself. Get those decisions wrong, and the client conversation is either incomplete or it doesn't actually protect anyone, including you. By the end of this video, you'll have a clear framework to work from: two conversations, a contract, and a contingency. And you'll have 5 specific things to do to get all of it in place. So let's get into it. I'm Rob Fornango. Welcome to the AI Growth Accelerator. I spent 27 years in data science and analytics, building AI systems for government contracts, leading data teams on 7 and 8-figure engagements, and teaching data analytics and strategy at the university level. What we do here is cut through the AI noise and show you what actually works in your business. Now, most people think that client disclosure starts with what you say to a client. It doesn't. It starts with two decisions that you make about your own workflow. Now, decision number one: what do your AI tools actually do with your data? Now, not all tools handle data the same way, and that difference matters for your clients. Consumer versions of AI tools, the free tiers and the standard subscriptions, may use your inputs to help train their models. And whether that's happening and to what degree depends on the platform and their current policies. The point is, you should know. Before you put a client's business situation into any AI tool, you should be able to answer this question: does this platform retain my inputs? And do they use them for training? API access and enterprise versions of these same tools typically operate under different terms. Data retention is usually limited, and training on your inputs is generally off by default or prohibited entirely. That's a meaningfully different situation, and it's not just the tools you're consciously thinking of as AI tools. A lot of the software you're already using has AI built into it now. Your note taking app, your CRM, your proposal software, your email platform, these tools are also processing your client's information. The same review applies. Find the data policy, understand what it says about retention and training, and know what you're agreeing to on your client's behalf. Understanding decision one and acting on it requires some work. Make a list of every AI tool in your workflow, including the ones with AI features you might not think of first. Find the data handling policy for each one and know whether you're operating on consumer or enterprise terms. Now, decision two: what are you choosing to put in? This is a completely separate question, and it addresses a different risk. Even if you're using a tool with strong data handling protections, the choice of what information you actually input is still yours to make. And this is where the traffic light rule comes in. There's a link to my video about the traffic light rule in the description below. If you haven't watched that video yet, the short version is: not all information belongs in an AI tool. Red zone information stays out. That means client names, company names, specific financial figures, health situations, legal matters, personnel issues, detailed competitive strategy. These aren't labeled handle with care, they just stay out of an AI entirely. Now, green zone information is things like general industry context, publicly available information, or non identifying descriptions, and that can go into an AI. The yellow zone is where you're going to have to use your judgment and err towards the side of caution, and my video tells you more about what belongs in the yellow zone. I want to be specific about why these two separate decisions are important, because this is a point that most people miss. Think of them as two complementary layers of protection. Your input discipline is the primary layer of protection. If nothing sensitive goes in, the retention policy has nothing to impact. Tool selection is the safety net, though, for when input discipline slips, and it also covers the general context you'd legitimately put into the tool. You need both, but they're not equal, so get your input decisions right first. Now, before we move on, if this is landing for you so far, go ahead and hit that like button. It tells YouTube to show this video to other small business owners who need to work through the same thing. And if you're not subscribed yet, hit subscribe too. I put out new videos every week, and each one is built around giving you practical AI workflows and strategies that you can actually use in your business. Now, before we go any further, I need to say this clearly. I am not an attorney, and nothing in this video should be construed as legal advice. AI regulations in the United States vary by state, And what applies to your business depends on where you operate and where your clients are located, and those can be two different things. It's on you to know the rules that apply to your situation. If you're in a regulated profession, like a therapist or financial advisor, attorney, licensed healthcare provider, or any other licensed professional, then your licensing board likely has specific requirements on top of everything that we're going to cover here. You're going to have to know those rules too. And this video doesn't substitute for those. Now, let's talk about the regulatory landscape. The US doesn't have a single federal AI disclosure law right now. What we have is a patchwork of state laws, federal agency enforcement through existing consumer protection rules, and more regulations are coming fast. Now, the FTC is already active on this, and under Section 5 of the FTC Act, misrepresenting how you work, including by not disclosing AI's role in your services, falls under unfair and deceptive practices. Now, that's today, not a future risk. So state laws are multiplying, and one thing that catches people off guard, the law that applies to an interaction can depend on where your client is, not just where you are. So we'll come back to that when we talk about the contract in a minute. But look, the more immediate driver for most of you watching this isn't legal, it's relational. Clients might be starting to ask whether AI is involved in your work. And if your answer is vague or you're caught off guard, you've created a trust problem that didn't need to exist. At its core, this is about trust and about doing right by the people who hire you. So legal compliance sets the floor you need to meet, but the standard you should actually be aiming for sits higher than that. So now we get to the client-facing piece. The first conversation you're going to have is about data use. You're telling clients that information about their business may be used as input into AI tools as part of how you work, and you're telling them specifically what you do to protect that information. Now, two things to nail before we get to the language. First, you need to be precise about what you don't put in. A lot of people default to saying something like, "We anonymize your data," but that phrase oversells the protection, because true anonymization is harder than it sounds. If I describe your industry, your revenue range, your market, and your competitive situation without using your name, there's a reasonable chance someone could still identify your business from that description. The more accurate and honest framing is behavioral. Say exactly what you don't include: names, company names, specific financial figures, and identifying details. Describe the practice, not necessarily the outcome. Second, this conversation happens at onboarding, spoken out loud, and it should be a deliberate moment, not buried in a paragraph 7 of your welcome email. You need a real moment in your onboarding process where you're looking at the client and you're saying this. It might sound something like this. Before we get started, I want to take a couple of minutes to tell you how I use AI tools in my work and how I handle your information. I use AI to help me work more efficiently, things like research, drafting, and analysis. When I do, I'm careful about what goes in. I don't include your name, your company name, or specific financial or strategic details. And I use tools configured to protect client data. You'll also see this covered in our agreement, but I want to say it to you directly. And that's the whole thing. A minute of your onboarding time and it's done right. Now you might ask, what about clients that you're already working with? Well, if you've been using AI in your workflow and haven't had this conversation yet, then you need to have it. And it's less uncomfortable than it might feel right now. This isn't a confession. It's a proactive disclosure about how you work going forward. So keep it forward looking. Something like, as I continue to evolve how I use AI tools in my work, I want to make sure you understand my approach and how I handle your information. You don't need to make it a dramatic thing, and you don't need to over-explain it. Keep the tone matter of fact. You're updating a client on how you work, and most clients are going to appreciate that you took the time to be upfront about it rather than saying nothing. Now, the second conversation is the one most people aren't having, and it's becoming the more important one. If AI is helping you create the deliverable a client is paying for, meaning the strategy document, the coaching summary, the proposal, the content plan, the email sequence, does your client know that? There's a useful spectrum to think about here, and it'll help you figure out where you actually sit. On one end, you use AI to brainstorm, to research, or to generate options. And you take those options, you develop them, and then you rewrite them, and the final product reflects your judgment and your expertise. AI was the tool in your process, but the output is yours. On the other end, AI generates the primary deliverable. You review it, edit it, and stand behind it, but the client is largely receiving AI generated work. Now, both can be legitimate, but the further toward that second end you operate, the stronger the expectation that your client knows. Now, for coaches, if AI is drafting your session notes and follow up summaries, it's worth disclosing to the client. For consultants, if AI is generating the first draft of the strategy document your client is paying for, that's worth disclosing as well. For online businesses, if AI is writing the email sequence or content plans you're delivering to clients, it's the same thing. Now, right now, this is more about professional trust than legal requirement, but that gap is changing. Clients are forming their own expectations about this faster than the law is catching up, and getting ahead of it is the right move. There's one more piece of this conversation, too, that's worth having, and most people skip it entirely. When AI generates significant portions of a deliverable, the ownership question gets complicated. Copyright protections depend on human authorship. And when AI does a substantial amount of the creating, the rights picture isn't as clear cut as it is for work you built from scratch. There's also some level of uncertainty about what the AI drew from when it generated that output. For most of what we're talking about here, this won't be a practical issue day to day. But if a client is going to build something significant on top of what you give them, a brand identity, a course curriculum, a core business strategy, they should know that copyright status of AI assisted work is a different question than the copyright status of work you created entirely yourself. That belongs in the conversation. Both of those conversations need a written home, and that means your service agreement needs an AI use clause. This clause needs to do three things. It needs to document conversation one, how you use AI tools in your process and what you don't put in. It also needs to document conversation two, that AI may assist in the creation of deliverables. And it needs an acknowledgement that the client has been informed. Now, that last part matters. The contract creates a record that the conversation happened. And a plain version of that clause looks something like this. Your business name uses artificial intelligence tools to support service delivery, including research, drafting, and analysis. Client information used in this context will not include identifying details such as individual names, company names, or specific financial figures. AI tools may also assist in the development of deliverables. Your business name maintains human oversight of all AI assisted work. Deliverables represent your business name's professional judgment applied to AI assisted output. Ownership of final deliverables is as specified in this agreement. Now, that's really all you need, plain English that any client can read, and it covers both conversations in a single clause. That last line about deliverables matters too. It establishes that what you're handing to a client is the product of your professional judgment applied to AI assisted output, not raw AI output on its own. And it points ownership to wherever it's defined in the rest of your agreement, which is where that belongs. The AI clause isn't the place to define intellectual property ownership. It just needs to acknowledge the question exists and tell the client that it's been addressed. One thing I want to flag that I can't resolve for you, and that you actually need an attorney's input on, is the question of whose state law governs your engagement. A choice of law clause in your contract determines which state's contract law applies if there's a dispute between you and a client. What it may not do is exempt you from a client's state consumer protection statuses. Some states write their AI disclosure laws to apply to any business collecting that state's residents' information, regardless of where the business is based. Whether a choice of law clause can override a specific state's consumer protection requirements depends on the specific law and the specific facts of the situation. And that's an attorney's territory, not something you should be getting from this video. What you need to take away from all of this is that where your clients are located affects which laws may apply to you. So put that on your list to discuss with an attorney. Now, what do you do when a client says they're not comfortable with AI? The most important thing I can tell you here is to answer that question now before anyone asks it. Don't figure this out in real time while a client is on a Zoom call waiting for your response. The decision comes down to one question: is AI optional in how you deliver your service, or is it integral? If AI is optional, meaning you could do the same work without it, just more slowly or manually, then accommodating an opt out clause is a workable solution. You use AI for things that don't involve the client's information or deliverables, and you handle their work differently. Your service agreement should include a clear opt out clause that defines what that looks like in practice, if that's something that you want to entertain. If AI is integral, on the other hand, if your service delivery actually depends on it, then a client saying no to AI is effectively saying no to the engagement. That's a legitimate position, but it means the AI use needs to be disclosed as a condition of working together at the outset, before any contract is signed, not discovered mid engagement. And then there's the middle ground, which is actually where most coaches and consultants will land. A client might be fine with you using AI for your own processes, doing research, brainstorming, general drafting, but not comfortable with their specific business information going into it. That's workable. Use AI in general tasks, keep their specific details out, and handle those manually. Know whether you can operate that way before someone asks you to. The practical step here is to decide your policy now. Write it down, put it in the contract, and then know your answer before the conversation happens. So here are your action steps, the 5 things to do after this video. First, audit your AI tools. Make a list of every AI tool in your workflow, including the ones with AI features built in. Find the data handling policy for each one, and know whether you're on consumer or enterprise terms. Number 2, apply the traffic light rule to your current workflow. Look at what you're actually putting into AI tools right now. If any of it belongs in the red zone, change that today. Number 3, add an AI use clause to your service agreement. Cover both conversations, both the data use and the work product conversation. If you have an attorney, this is worth a quick review given the state law question that we just talked about. Number 4, add a spoken AI disclosure to your onboarding process. Make it a deliberate moment, not a buried paragraph. And if you have current clients who don't know you're using AI in your work, have that conversation now as well. Don't wait for them to ask. Fifth, decide your contingency policy now. Is AI optional or integral in how you deliver your service? What do you offer if a client opts out? Write it down before anyone asks. Now, if you want to go deeper on decision 2, specifically how to figure out which information is safe to put into an AI tool, which needs caution and which stays out entirely, I have an entire video on the traffic light rule that lays out a clear system for making those decisions. The link is below. I'll see you there.